Hello, and welcome to the Disability Law Q&A session with me, Martin Willemse. I'm a partner at the firm of Samfiru, Tumarkin, and the Western Canada Disability Practice Leader. I welcome all questions through social media platforms, and as they come through, I'll respond to them to the best of my ability. You can ask your questions now, send them in, and as they are in, we've got 30 minutes, so I'll try and get through all of them. One thing that comes up, and I've spoken about this before, is what happens when you have a workplace injury. And what many people don't understand is workplace injury doesn't simply mean a physical injury. It may also mean a mental health issue. So if there had been bullying and harassment in the workplace, and as a result, you develop a psychiatric condition, be it a generalized anxiety disorder or a panic disorder or major depressive disorder, and it's due to the bullying and harassment, you can claim benefits from WCB because the injury resulted as a result of your work. What do you do with your LTD claim then, with the insurance company that you have through your employer? Many people think that because they have the WCB claim, that they do not need to submit a claim to their insurance company, which is wrong. Under the terms of your policy with the employer, which is a contract, there are certain timelines that you have to abide by. So from the date that the claim arose, the date that you go off work, there would be a notice of claim provision and a proof of claim provision, and both of those have timelines. Notice of claim may be that you have to submit or at least provide notice within a certain period, be it 30 days or 90 days from the date that it started, and proof of claim may have a different timeline, but you have to abide by those timelines. So if you have a WCB claim and you don't submit a claim because to the insurer, because you think that your benefits are being paid by WCB, so what's the point? It may happen that WCB at some point denies your claim, or the WCB pays your claim for a period of time and then denies it, but you may still remain disabled. If you then decide to submit a claim to the LTD insurer, they may very well deny your claim, saying that you're out of time, that you should have submitted the claim months or even years earlier. So regardless of what the employer tells you, if they say, no, you've got the WCB claim, you do not need to submit a claim to the LTD insurer or the short-term disability insurer, that's not correct. You do need to do that in order to avoid a denial based on you missing a contractual timeline to submit the claim. Another thing that you should be aware of is if it is a workplace injury and if WCB does pay, under the terms of the group policies, the WCB payment would be a direct offset from what the insurance company has to pay you. And I suppose that's where many people's confusion comes in as to why they don't submit these claims to the LTD insurer. If WCB pays the claim, it likely will wipe out the LTD claim for the period that the WCB claim is payable for. So it's important to make sure that you do submit the claim. Even if they deduct it, the claim will still be adjudicated by the insurance company. And another thing to understand is if the insurance company denies your claim while WCB is being paid and you continue to receive your benefits from WCB, the denial from the insurer will trigger the running of what is referred to as the limitation period, the timeline within which you can pursue a legal claim. So if WCB continues to pay you benefits, but your claim had earlier been denied by the long-term disability insurer, that timeline still runs. So regardless if you are receiving WCB benefits and the insurance company then denies your claim, still make contact with a lawyer, still contact our firm so we can tell you what the limitation period is and what to do about the denial itself. At least give you options so you can make an informed opinion or decision rather. At our firm, as you can see on the screen, you can go to disabilityrights.ca for more information. At our firm, we offer free consultations. We practice throughout Canada. We've got offices in Alberta, British Columbia, and Ontario, but we do not practice in Quebec and the territories. So if you've got questions, you're welcome to contact our intake team, and if we're able to assist, they will direct you to a lawyer to have a free consultation. What we do is we review clinical records if they're available, but most importantly, the denial letter, the policy, and we'll discuss with you what your circumstances are so that you can make a decision as to how to deal with the denial. Okay, There's a question from Sammy B. If you are never able to return to full-time work but can do part-time, will the insurance company still give you a top-up? It depends. It's not an easy question to respond to. Some policies do provide for part-time disability benefits, others do not. But most policies will have a two-tier definition. The first one is for the first 2 years, generally it's 2 years, some may have 1 year, some may have 3 years, but for the first 2 years, you have to prove that you cannot perform the duties of your own occupation. Then the definition changes. Then you have to prove that you cannot perform the duties of any other occupation, including your own occupation, based on your transferable skill sets, and that would pay to you the same amount roughly as your LTD benefit amount. So, Sammy B, it goes to your question that if you get to the any occupation phase and you're able to work on a part-time basis in your own occupation or even in a part-time or in another occupation on a part-time basis, and the part-time income that you receive is equivalent to your LTD benefit or in the range of 65% of your pre-disability income, then the insurance company will likely deny your claim. If the income that you are able to receive is much lower because your capacity may be that you can only work 10 hours a week, then in theory, the insurance company should continue to pay you benefits because you don't have the capacity to work at a larger capacity to the point that you will no longer qualify under the any occupation phase of your policy. The moment that you display that you've got capacity to work, they may engage you to participate in a rehabilitation program that they mandate in order to get you to that threshold of being able to work 65 to the extent that you could earn 65% in any capacity. Remember, the any employment phase in your policy would be that you have to prove you cannot perform the duties of any occupation based on your that would pay to you something similar to your LTD benefit amount for any employer in any setting, even on a part-time basis, even working from home. These are things to consider when you do submit evidence in support of the any occupation phase if your claim is approved during the own occupation phase. Lots of cases do get denied at the any occupation phase. And again, if you do have a denial, reach out to us so we can discuss with you what your options are. You also need to know about something called a limitation period, which people don't understand. When you get the denial letter from the insurance company, there will be information in there that may be overwhelming. They're going to be speaking about an appeal period, and they may say you have to appeal within 30 days or 60 days or 90 days. Sometimes it's a longer period of time. But they will also speak if you're in a position where you could file a legal claim. Some people cannot when they're unionized, and the collective bargaining agreement provides that they cannot pursue a legal claim. But if you can, the letter should detail that there is a limitation period and that you should consult the Insurance Act in your province. What that means is once that claim is denied, if you engage in the appeal process, that does not interrupt the limitation period from running. The limitation period, again, is the timeline within which you can pursue a legal claim. And that timeline usually is 2 years. But the triggering event is always questionable. Is it the date that the insurance company denied your claim? Is it the date that you received your last payment? You need to have a discussion with the lawyer so that they can advise you when it started to run, how long it is. And you need to understand, very importantly, that if you engage in the appeal process, the limitation period does not stop running. If you do retain the services of a lawyer, at our end, our goal is to get our clients the best compensation that is available. And the way that we do that is once the legal claim is filed, our clients' focus would be to see their doctors regularly and to focus on their treatment. The insurance company can no longer communicate with our clients. All communications go through us. Our job is to try and get you the best compensation that is available under the legal claim, through the legal claim, I should say. Okay. I hope that was helpful, Sammy B. If you've got more questions, by all means, reach out to our firm. As you can see on the screen, which will pop up in a second, you can go to disabilityrights.ca for more information. Okay. A question on YouTube from Peter. Peter says, how long does an LTD insurer have to respond to an application? If it's been 6 months since my application, I haven't been heard anything, should I be worried? 6 months is quite excessive. In the policy, there isn't a timeline generally as to how long the insurance company would have to respond to your claim. Having said that, LTD policies, peace of mind policies. What that means is when you purchase this policy or when you became enrolled as a member through your employment, an insured member under the policy, these peace of mind contracts are supposed to provide exactly that, peace of mind. That means that the insurance company has a duty of good faith to you, and they have to abide by that duty of good faith. And by not making a decision, I would argue that they are not doing that. So usually we get involved when there is a denial on a claim. Having said that, if the insurance company is not making a decision or they're not communicating with you, I would advise that you contact the insurance company, get the case manager's, supervisor's contact details, even their manager's details, and contact them and insist on a response within a timely period. You may also want to contact your human resources, tell them that the insurance company is not responding, and have them be on your side in contacting the insurance company as well. That often does happen. But if this carries on and there is no decision that has been made, you're welcome to contact us and we can discuss what other options may be available to you. There was another question. So Irmal Yasilad, I hope I pronounced that correctly, asks, what is going to happen if I go back to work before the IME? Well, if the insurance company has denied your claim, then you've got various options. But if you decide to go to work, I would want to know whether you've got your doctor support to do that. If you do go back to work and you find that it's premature, your policy really should have, depends on where you are. If you're receiving an LTD benefit, most LTD policies have something called a recurrence provision, so that if you return to work to full-time duties and you go off, generally it is 6 months, within 6 months, due to the same condition or illness, then it would be a recurrence of your previous claim. If you go back to work, I would say make sure that you've got your doctor sign off. Is a graduated return to work? If you do go back on a graduated basis and it's mandated by the insurance company, make sure that during that graduated return, you see your doctor as regularly as possible. Because if you find that your condition worsens, you want your doctor to know that. You want your doctor to record that in the clinical entries so that if you go off work again because your condition has worsened, and you request the insurance company to reopen your claim, or if you were to submit a new claim, you want to submit those records to indicate that you did see your doctor, that the doctor did detail that your condition was worsening. I always advise people to follow their doctor's advice. So if your doctor is suggesting that you go off work again, I suggest consider doing that. If your doctor is suggesting that you lower the hours that you're working, I suggest you do that as well. Insurance companies are very focused on getting people back to work. I don't think there's anything wrong with that aspect, but it should not be done in a context where there is no medical support and if the return to work is actually worsening the person's condition. I speak to lots of people who have gone back to work who are struggling, or where the insurance company is saying, we've had an IME done, or our in-house doctor says you should be able to go back to work on a graduated basis, and we'll allow you 2 months to get back to full-time hours. And then the doctor doesn't agree with it, the treating physician. Then there's a question is, what do I do? So if that is a situation that has come up in your with you, please reach out to us and we can discuss this in further detail. Irma, I hope that answered your question. I'm not sure if I've got enough information, but that may happen. So make sure you see your doctor regularly. And if your doctor mandates suggest that you go off work, I suggest you follow your doctor's advice. And if the insurer denies your claim, contact us. Again, disabilityrights.ca. You can see on the screen, you can go there for more information. Then there's a question from, I hope I pronounce this correctly, Loyal, Loial. If your claims adjuster refuses to provide documentation of phone conversations, what can you do? They are very pushy. This is an interesting question. Sometimes insurance companies do record telephone calls with their insureds. Other times they do not. Consider where you are in what province you are, because you may want to consider applying for a copy of your file, make a formal request, and in some instances you can even do a freedom of information request from the insurance company to provide you with a copy of your file. Consider also making notes when you speak to the insurance company so that what you say to them, you can consider whether that is accurate. I've seen lots of cases where we do pursue a legal claim. The insurance company then is mandated to provide us with a complete copy of their file. And then we get the notes made by the claims adjuster or the case manager, and what the person, our client, says what was they were discussing with the claims adjuster is not accurately recorded in those notes. So when you do speak to them, make notes for yourself to know what was said. BC Pinoy says, what are the pros and cons financially for applying CPP disability while in LTD? That is a very good question. So on the one hand, CPP disability benefits are taxable. People quite often, especially if their LTD benefit is not taxable, don't like that idea. Another thing that you can do when you do apply for CPP disability benefits is also apply for the disability tax credit, which hopefully will allow you some tax credits to offset the tax consequences of the CPP disability payment itself. Under the terms of your policy, your group insurance policy, it may be required that you have to apply for CPP disability benefits if you are eligible for those. And if you don't, then the insurance company may simply estimate it, because at their end, under the vast majority of group policies, the insurance company can deduct the CPP disability payment. But here's, in my mind, what I believe are the positives of CPP disability. Lots of LTD policies do not have a cost of living allowance. In other words, a yearly increase based on the consumer price index, or a minimum or a maximum percentage in your LTD policy, where annually your LTD benefit may increase. Lots of policies do not have that. At the other end, CPP disability does have that. Every year, your CPP disability benefit will increase. Under the terms of the vast majority of LTD policies, that increase, that annual increase, is not subject to the offset provisions. In other words, the insurance company cannot deduct that annual increase. You may also be eligible for child benefits. So if you receive CPP disability benefits, child benefits may come into play. And generally, those are not deductible under the direct provisions of your policy. They may be deductible under what is referred to as indirect provisions. Once CPP disability is approved, you, unlike with an insurance company, will not be subject to constant evaluation and assessment as to whether you continue to be disabled to receive those benefits. Once it's approved, it continuously remains to be paid unless the CPP disability, the adjudicator said, well, we're going to reassess within 5 years. But they don't do it to the extent that an LTD insurer does it. The argument would also be, if CPP disability is approved, the test for CPP disability is you must have a condition or an illness that is, number one, severe, number two, prolonged, and number three, prevents you from engaging in any gainful occupation. So in theory, the government then is accepting, if it is approved, that you cannot work in any gainful occupation. Your condition is severe and prolonged to the extent that it prevents you from engaging in any gainful occupation. Consider the LTD provisions in the policy. When you get to the any occupation phase, the any occupation phase provides that you cannot perform the duties of any occupation based on your transferable skills that would pay to you an amount similar to your LTD benefit in general. If CPP disability is approved, you have an argument to make that even the federal government accepted you cannot work in any gainful occupation. They're not concerned about what your benefit was before to make sure that you can earn a certain amount of income. They're simply looking at, can you work in a gainful occupation, yes or no? And if it's no, they will approve your claim. So I would say it supports your claim that you should be entitled to LTD benefits. An insurance company at the other end will say, well, we look at entirely, completely different criteria. But again, it's in their interest if CPP disability is approved. In your interest, if that CPP, if the LTD claim is denied, you should continue to receive your CPP disability benefit. CPP disability is not contingent on the LTD claim being approved. So there are various reasons why a CPP disability application may be of interest to you and may actually be beneficial to you, considering everything that I've just said. I hope that was helpful, BC. Lee says, if I am told by LTD, I'm approved for 1 year. Why do they need to check in every 2 to 3 months? Is this normal? Is the check-in with me or with my doctor? If they say to you that you are approved for 1 year, I do find that surprising because they don't generally approve people that far into the future. But I think I would want to see the actual letter if they did say that to you. What they'll do at their end is they'll continue to adjudicate the claim. I've seen people provisionally approved, where the insurance company may say, and this doesn't happen often, but they may say, we have accepted that you continue to be disabled until the end of the own occupation period. However, we will check in with you to see whether you have had any improvement or whether there is a supported gradual return to work. If you do go back to work, of course, we're going to change our position. This may happen in the context where somebody has a surgery that's coming up and the surgery date is unknown. And the insurance company may say, well, we're going to approve this claim, but if the surgery happens earlier and after the recovery period you're able to go back to work, we're going to deny the claim. But it does not often happen that they would say to someone, we're going to approve your claim up until a year from now, because they don't have the evidence to support, unless it is a progressively worsening condition or a terminal condition, that I could understand why they would do that. The check-in with you would be generally with you, where they would have a telephone discussion with you, or it may also be that they may approach your doctor to complete a questionnaire, or where they may have you complete activities. And this is always a concern for me, where an insurance company provides to an insured daily logs to complete, activity logs, because they're trying to establish, is what you're saying to them accurate, because they may at the same time conduct surveillance. So if you do receive activity logs to complete them accurately. Consider what you've reported to be your restrictions and limitations to the insurance company. Is that consistent with what you're doing every day? Because at the same time, they may conduct surveillance. And if the surveillance shows that what you've reported is not consistent with what you completed on those forms, and with the surveillance that they can see that you're actually more active, they may deny your claim based on you being more active and that what your reports are not consistent, which ultimately becomes a credibility issue. I hope that was helpful. Emil says, thank you. You're very welcome. Royal says, they repeatedly ask me questions about my functionality, and I think they have sent an investigator to record me. So, Loyal, what you're speaking about is surveillance. And that does happen, not in all cases, but it does happen. So if they continue to ask you about your functionality, they have phone discussions with you. So they may phone you and ask you a bunch of questions. These are called functional telephone interviews. So when they do these, they will ask you, what house do you live? Is it house? Is it condo? Is it townhouse? With whom do you live? Do you have children? Who take care of the children? Who takes care of the children? Who prepares the meals? How do they get to school? Do you have a yard? Do you have a pet? Who does the household chores? Do you banking? Do you drive? They're trying to get information from you as to how your disability impacts your ability to perform the activities of daily living. Now, of course, and this is always an issue, what you're able to do in your regular life doesn't necessarily translate and equate to what you would be able to be required to do, what you would be required to do, and what you actually were able to do in a work setting. But that's often the case. I've seen lots of cases denied where an insurance company does a functional telephone interview, asks the person a lot of questions. The person may have made a claim for mental health. They may have said, I have panic attacks. I have a low mood. I don't really want to get out of bed. I cannot deal with other people. I cannot handle any form of conflict. I work as a bank teller. Therefore, I cannot work. Then they ask him, what do you do in your average day? The person may say, well, I've got kids. I have to take them to school. I work in the garden. I do my household chores. And somehow the insurance company then decides based on that the person is able to go back to work because they're able to manage those activities of daily living, which are not nearly the same as doing the job of a bank cashier, where they would have to deal with people, they would have to focus, they would have to concentrate, they have to manage difficult customers, they would have to multitask, they cannot make mistakes, which cost thousands of dollars. To equate that with being able to do gardening and taking your children to school, it's completely different. Therefore, in those situations, when these cases are denied, we do get involved and we do make a big deal about these things when we are acting on behalf of our clients. So our clients can again focus on their treatment, focus on seeing their doctors, and leave it with us to try and manage the best way that we can to get them the best settlement available. That is done through legal claims. I hope that helped. Then there's a question that says, if I take up a hobby while I am off on LTD, am I allowed to sell my work at all, or will this cause problems? This is a question from Layla on YouTube. So, interesting. Consider what I just said. When insurance companies consider what you do in your activities of daily living, and they're trying to see, do you have function? Can that function then be correlated into a setting where you can work, depending on where you are in the claim, in your own occupation or maybe in another occupation? So to you, Layla, when we have this question of, can you sell your work? It tells me you've got a hobby, which may be painting or maybe pottery, whatever it may be, and you want to sell your work. The insurance company is going to look at function, number one. If you're able to do things that may translate into a form of employment, be it self-employment, and you would be able to make money from that. It depends on how much you would be earning, because it would be deemed to be income. And there are some pitfalls there, because some insurance companies do say, policies provide that if you work in any other setting other than in an approved rehabilitation plan, that benefits will be terminated immediately. Others may say that if there is income that you're making from a specific form of employment, which this would be, it would be self-employment, then that forms an offset. But the bigger question would be, in my mind, the function. If you're able to do these things, and it depends on the extent of it, how much capacity it is, what your pre-disability income was, whether you're in the own or the any occupation phase of your policy, how will that, your activity, your hobby, from which you may be able to make income, how will that impact the LTD claim itself? So I strongly recommend that you contact us and we could understand where in the process you are, what exactly it is that you're proposing to do, how much money would you be making from it, to see whether it will have an impact on your claim. Okay. There's a question from Thomas on Facebook that says, I applied for CPPD after being urged to do so by my insurer. I was denied as they suggested I could still likely find an occupation. Now my insurer has also said they will be cutting me off. What should I do? I'm not ready to return to work. Firstly, with CPPD, make sure that you don't miss the application to apply for a reconsideration of that decision. My understanding it is that you have to do so within 90 days of the denial of your CPP disability application. With respect to the LTD denial, contact our firm and we can discuss with you on a free consultation basis what your options are. Generally, when an insurance company is denying a claim, considering what I'm reading here, that they say you can find a different occupation, the insurance company may be denying your claim at the change of definition, which then tells me that they feel you can work in another occupation based on your transferable skills that would allow you to earn an amount of income similar to your LTD benefit amount. So in that situation, you really have to make sure that you have your doctor on board, speak to your doctor, have your doctor give an opinion as to whether he or she agrees that you can go back to work in another occupation. But before you do any of it, I would suggest contact us so we can understand more about your claim. As I said earlier, lots of people get denied at the change of definition phase. Again, go to disabilityrights.ca for more information. When you contact our intake team, they'll get some information from you and they'll refer you to one of the lawyers to have a free consultation. And then we would discuss what the denial is, why it has been denied, and what your options are, because you do have options. You don't have to retain us. You can make your own informed decision, but at least you'll know how to proceed. Laura Lee H says, hello, if an LTD claim is approved through the next 12 months and the LTD provider is requesting, I assume the question is medical, 3 or 4 times in that 12-month period, who is responsible to pay the doctor fees to fill out the additional medical? If it is the employee, I guess they can claim it on an income tax. So it's interesting because mostly when a claim is approved and the insurance company is requesting further information, they usually request it directly from the doctor and they pay for it. If the doctor isn't providing it, at some point they may reach out to you and say, look, we need you to go to your doctor to make sure that the doctor provides us with the records. So that's my understanding. That's what I've seen happen. If the claim is denied and you're in the process of an appeal, then they will say to you, you are responsible for the cost of providing evidence to support the appeal so that we can consider whether we will be overturning our decision. Can you claim it on the income tax? I suppose it's a good question. And I would think, yes, that makes sense. I cannot give you tax advice, but it makes sense to me that you would be able to do that. Okay, so teacher says, my school board is not paying me after I gave 3 doctor's notes for mental health. They require an IME and I have agreed. I have not seen one yet. Shouldn't the board pay me as I have sick days? It sounds like it's a unionized situation. In those situations, we cannot generally assist. I do recommend strongly that you speak to the union to have that discussion, whether they would be able to convince the board to assist with sick days. Jake, the good guy, says, hey, I'm presenting a big mess of text to my legal team. How best can I organize and label everything that an attorney would appreciate and find helpful? I don't know if that really is a disability-related question. I suppose contact your attorney and have a discussion with them as to how they would want it to be presented to them and take it from there. With that, it brings us to an end of the session. Thank you. There was a lot of questions. I appreciate those coming through. If you do have other questions, contact us, disabilityrights.ca. Go there to that website. There will be a lot of information that would be helpful. If you want to speak to one of our lawyers because you've got a denial or a question, contact our intake team and they'll refer you to one of our lawyers to provide a free consultation. Our next session will be an employment law Q&A on Thursday, March the 20th. So that's in 2 days from now, at 2 p.m. Eastern Standard Time with Jeremy Herman. Thank you again. I will do another one of these on April the 1st. So please tune in if you've got further questions. Thank you and have a great day.